The night of the 19th of January 2023, you're very welcome back to the channel. I have my notice up here, my strategy. I'm not out to uh, complain about platforms or anything else. I have a strategy and you can see the way I work. If I'm not going to get my message across on one channel, on one platform, I'll go somewhere else. But for the moment anyway, I'm going to stick with YouTube and Rumble and hope that works out. And it's nice to be on both. This shouldn't cause any problems. Now, as you know, I am campaigning against all the energy and projects and, as I said, junk that's been imposed on the Irish countryside, that's destroying the grouse species, that's destroying their habitat, and that has destroyed 50,000 trout and a similar amount up in Donegal, in total and utter wanton destruction of the environment for greedy wind developers, pylon developers, and other developers who are not complying with the law. I have never objected to a private house or any development. There was an estate going up in near where I had a house, and I did object originally, and then we settled and we come to an agreement with some minor amendments. I'm not a serial objector to anyone building anything. I'd say you could build almost in damn near on my own ground before I'd actually complain. So I am not a serial objector, and I like to see business and progress. But I still like that the law that was offered to us when we joined the EU be upheld. Now, one of the consequences of not complying with the rules is that when I was growing up, there was a lovely market house in Kingscourt, a lovely market house, and it was there from the landlord times, but it was a good structure with an alleyway through it that you could drive lorries, and it was good and high, and there was a lovely clock over it, and it was pulled down. And I was listening to the people at the town complaining all through my upbringing, and when I got big enough to go into businesses and hear people talking and pubs and that about lamenting pulling down the market house. Now, I was too young, I couldn't do anything about it. I'm not too young now. I see this destruction going on, and I roll up my sleeves and I decide to do something about it. And I'm rather unique in that situation. Now, this is 51K, access to information on the environment EU regulation, right? So 51K. Now the directive is 2034, that's 2034 EC, 2034 EC. And it's incorporated into Irish law by statutory instrument 133207. And there are subsequent amendments to it and subsequent amendments to the directive that anyone putting it in knows about. Now, I have plenty of templates for doing it, and I can give them to anyone who uses them, and I do share them with groups who want them. Now, the SEA directive is the directive for the overarching plan and programs for many things, including energy, agriculture, fishery, forestry, and everything else, and it was never really obeyed. Now, when we try to beat the wind farms and that with the EIA, the local planning commission directive, we sometimes won and we sometimes lost, and the courts would sometimes appoint a judge who wasn't sympathetic and sometimes they'd appoint one who was. But I began to say to myself, is there not something larger than this? And there was. It's the SEA directive. The overarching plan or programme has to carry out an assessment. There has to be an assessment for each industry and each business and each sector. And that assessment has to be done with public participation, and it's quite a chore. And the regulations is very specific, and there's an annex to the SEA directive, and it's very specific about soil and water and the impact of human health and all of that. Now, years ago, I was in the Chester Beatty Library at the launch of a green document about 2013, and I must try and get it on the internet and give you a look at it when I can. I think it's still there. And I brought this up before the minister, the head of EirGrid, the whole thing. And there was a man there, a man of about 70, and he was there, and he seemed to be a little sympathetic. But he went on to explain to me that the SEA directive is soft law. It means that it's soft law. It has no teeth as such. It's only a guideline. But yet, when I read the SEA directive, I saw it was specific. An environmental assessment shall be carried out, and based on that assessment, an environmental report shall be compiled. So there has to be a document, a piece of paper, an environmental report. That did not look to me like soft law, but it was seen by the bulk of the barristers and legal people in Ireland as not the law, and it was kind of seen the same by the judges, who just did not believe that an old farmer from Cavan could, and an engineer, Pat Swords, who's not a farmer from Cavan, and indeed Friends of the Irish Environment, they tried it. They were kept out, and Pat Swords was kept out of the European Court of Justice on the grounds that the group he was on about wasn't properly registered. But having been kept out of it doesn't mean that the Court of Justice itself is not right. It would do the job if the case could be got before it. So that was the struggle, how to get that before it. So the SEA directive is 201/42 EU or EC, and Article 2 to 4 are the relevant articles. And in a directive, you have the preamble. That's the wish, what it's for. It's only persuasive, it's not binding. And you have the annexes at the other end. But in the middle, you have the articles, and they're the legally binding bit. They are as legally binding as Section 49 of the Road Traffic Act in Ireland that forbids drunken driving. Just as tight, every bit. As I said there, one of the effects of not compliance was the market house in Kingsford. I'm not cribbing about somebody knocking out a bit of a ditch or that type of thing. I don't really like that petty kind of application of the rules, but for big things it is. Now, this 3 cases were brought before the Irish High Court. 3 cases. One by Mr. Swords, separate to the application of the European Court. And one by myself before Judge McBarrett, and both of them rejected it and said, no, you're wrong. But we were not wrong. And Friends of the Irish Environment, who are really a climate change crowd, we wouldn't have much in common with them, but they too, probably getting some state money, have taken a case. And the High Court judge in that case as well rejected their case and threw it out. Yet that didn't make sense, because that's not the law at all. So it's clear that the High Court people and the President of the High Court was allocating judges to these type of cases to stop it getting the SEA being applied. But he'd allocate good judges, and there are some good High Court judges who will study the thing real well, but they weren't getting their hands on it. So when you went up, you didn't necessarily get the best judge. And this, I believe, was a type of conspiracy. I'm not a particular conspiracy theorist. But 3 judges said no, the SEA directive doesn't apply. In the case of I hadn't the resources to go ahead. When you're in with so many barristers and solicitors against you, you are on your own. It's even taking notes is very difficult. And I was doing it as a lay litigant. So we couldn't get barristers, and we were searching for barristers who would agree that this is the law, and it was nearly impossible. Most of them said, that's not the law. But then, in some cases, the barristers are making so much money on other things that you wouldn't nearly get them, and you'd have to pay them a fortune. But the Friends of the Irish Environment were lawyered up. I don't know what their funding is. And they went through the High Court, and they were thrown out. No, you don't see under this. I mean, it says an environmental report should be compiled. Oh no, threw it out. And they went on to the Court of Appeal, which is a sort of a centre court between the High Court and the Supreme Court. And I would have thought that's not appropriate for. I have to check the law on that. But anyway, the judge in the Court of Appeal said their High Court was right, threw it out. Not at all. Okay. So meanwhile, they appealed to the Supreme Court, which is the highest court in the land and responsible for protecting the Constitution and EU law in Ireland. And 7 judges out of the 9 read the case and gave their judgment. and all of them ruled that there is something to it, and that this should be sent to the European Court of Justice for an opinion. And it's gone to the European Court of Justice. The number is 727 of 2002. So here we had 7 Supreme Court judges overruling the Court of Appeal and 3 judges in the Irish High Court. 3 judges had a different opinion than the Supreme Court. And I believe this was all a bit of a racket when you went up against these lawyers and the firms of lawyers representing the state, and they were before the High Court. They knew very well to put on a bit of a show and the judge would throw it out. And I have had a case myself since where the judge said there was no sign needed on an entrance to a place where there was a structure going that needed planning permission. The judge said, no, it doesn't need any notice, when in fact Article 19 of the regulations on planning says you do need a notice. Anyone common sense would know that. He looked down at me and he says, here's a farmer from Cavan, I'm not giving him anything. So you see the struggle it is. Now the thing about it is that meanwhile we couldn't get in on the overarching plan or programme for energy, the big picture, the big plan or programme. We couldn't get stopping it and insisting that the SCA be done and that the assessment be done. We couldn't get in on that. But meanwhile, over in Belgium, the Belgium group had a wind farm very close, similar to Rara, and they went into the court and ended up in the highest court of the EU. And the EU court ruled that the wind energy guidelines of 2006 in Belgium, which are the same as the ones in Ireland, which sets out the setback distances from houses, noise, shadow flicker and all that stuff, it ruled that those regulations had never been assessed, and they challenged the Belgian government to show where they had done the assessment, and the Belgian government couldn't produce anything, and they were relatively honest. And the European Court ruled, 1, the guidelines are a plan or programme, they're part of a plan or programme. 2, they're not assessed. And 3, the wind farms cannot be granted permission. They cannot be granted permission with these guidelines because they're illegal. And then it went on to say that all existing wind farms built under the 2006 guidelines have to be annulled and taken down. So my long-term goal is to pull down all the wind farms in Rarabis, in Kingscourt, in Tahart, and in Tewarker. But that will take a bit of time, and I want to be ready. It's something you just don't take on. It will be quite expensive. And then to take down all the wind farms all over the Republic of Ireland. That's my objective. Now bear in mind that the government was ordered by the EU to take down the Derrybrine wind farm in Galway, which killed 50,000 trout, and it's still facing down the EU. So they don't give up easily, but that doesn't mean we don't fight them, and it doesn't mean we don't have a bit of fun fighting them, because it's great fun fighting them. Now you see, when this came out, 2 judicial reviews went in, and a group was refused entry into a council offices, and I had to kick a bit of ass and got in there. And 2 cases have already been before the courts where the non-compliance with the SCA directive on the guidelines was included with other old grounds like bridges and roads and rivers and all that. And in every case the board conceded on the other ground because they don't want a precedent set on the case 2419. And we know that. We know that's the case. I know well what's the case. Now, when you go in on a judicial review on planning, or indeed anything against the Irish government or the Bord Pleanála, they will hire a firm of solicitors. One of them is Mason, Hayes and Curran, one of them is A&L Goodbody, and one of them is Philip Lee, and there's a few others, just not too sure. They're ones I dealt with. And they're big firms of solicitors, and they get huge money, and their job is to beat you at all costs. And what we're doing now, what I said to myself was we'll put in an access to information The access to information is a bit like, as I said, it's like a freedom of information on the environment. It's free, and they have to give you an answer. You put it into the government. The next one I do will be into the Taoiseach's office, and he has to send it to whichever department, and they're obliged to give the answer. There's a bit of an exception for national security. There's a bit of an exception for certain sensitive information. But by and large, I said, instead of waiting for them to grant a wind farm again, we'll put in a freedom of information or access to information request, and we'll ask them, is there an environmental report under the SCA directive for Irish wind turbines? For the 2006 wind energy guidelines. Include the wind energy guidelines, and then ask them, is there an environmental report? Now, I helped a few groups, and a few groups put them in, and they put too much in it, and there was mistakes made, and every time they write back, in one case they wrote back to one person and they said, will you agree to have this dealt with outside the regulation? And we'll refer to our business unit. So straight away they didn't want to answer. And I have no doubt what the Irish state does when they get these access to information requests, they send them over to one of these firms, the lawyers, to advise them what to write, because they know if they write there's no environmental report, that'll be used in the next case against them. So they don't want to provide the information to beat them, but they have to give it. In any event, when they don't give it the first time, you can get an internal review, you can get a senior person of higher rank to do it, and they'll rumble it about as well, and then you go to the Ombudsman. So at this stage, people are not able to handle it right, they don't know how to do the appeal, the thing of that, and as I say, just here, going back, I had a slip here. Seven judges, Supreme Court disagreed with and agreed that we were right, and that was it. But in the case of these access to information, they're writing back to say, oh, it's a budgetary thing. It's budgetary, and it's a policy. It's not a plan or program. So there are people there, if you search the newspapers and the news, who are forced to take down houses to build without planning permission. No plan of permission, you must take it down. One man has a big fine house and he has to pull it down. It's ordered him. Well, why don't they let him away with saying he didn't? It wasn't a plan to build it. It was a budget, or it was a policy. See, they use this, but the ordinary citizen cannot use it. Do you get my point? So they're trying to get away from. They're trying to say they don't need the environmental report because it's a budgetary measure. I mean, you build a house or you build a wind farm, you put forward the money. You have to. So this is the lame excuse they have, and this is the way they're trying to get out of it. So, so the thing about it is, anyway, it's now time for Clint Eastwood to come on the scene. I'm going to be rolling up the sleeves, and I'm going to send in my access to information request, and I'm going to say nothing other than, I'm going to say to them, here is a copy of your Wind Energy Guidelines 2006 attached. I request on information is there an environmental report in existence for the assessment carried out prior to the adoption of these 2006 guidelines? And then I'll say the answer required is positive yes or negative no. No other information is needed. That will go to the Taoiseach. They have to send it to the department concerned, and they have to reply to you within 30 days or give you an extension reason. They can extend another while. They're going to try and give me the same, and then the sparks will fly, because I won't give out to them at all. I'll bring them through the motions, and then when they refuse to do it, I'll hit them with the Ombudsman. There's an Ombudsman employed to rule where there's a dispute. And this is the problem with many groups, they get that hard to do. But to me, it's grist to the mill. So I'm going to sock it to them, and I'm going to do it now, hopefully this week. And they're going to run to their lawyers. They're going to say, he's only an old calving farmer, and I will give them no mercy. They'll not write to me and ask me to deal with it outside the regulations. They'll not they'll refer to any business unit they like, but they'll either answer yes or no. And if they give me any other answer, I'll seek my internal review, and then we'll go to the Ombudsman and we'll force the Ombudsman to rule on it. And if the Ombudsman decides against me, we can then use that in a complaint to the Aarhus Compliance Committee to say that Ireland is not compliant with an EU environmental law and the Aarhus Convention under which it was drafted. So you see what we're doing and what I'm doing. We go the whole hog. And the beauty of this is, and people may not understand this, if you wait till a wind farm is granted, you have to go through this process. This process could take 90 days. We need to get it in now. I'll have it in, please God, soon. And it'll go in, and then while they are getting ready and preparing for all these heaps of wind farms they're going to build, I have it in the mixer. And hopefully, by the end of the process, I'll have some result. And then I'll go into a Commissioner for Roads and I'll swear an affidavit to say on such a date I put in a document number marked A, this request for information. I got all this back, waffle. I then sought an internal review under the regulations. The senior person in the department waffle again, refused to answer. Here is the answer he gave. I then appealed to the Ombudsman, and this is the answer I got. So we put them to that trouble. We make them cringe and see how all these fancy lawyers are going to deal with it. The mistake was made in the beginning. We assumed these were decent people. I'm sure there are decent people dealing with these, but they're under order from the like of Mad Eamon Ryan and all these fellas. They're under order. So we're not dealing with decent people. You have to hem them in. You can't give them an inch. You have to have the time limit from the adoption of the SEA directive until the 2006 guidelines were brought out. Was there an assessment done prior to their adoption? So now I'll be keeping you up to date on that, folks, and how I play these people just like a fish on a fishing rod, testing their wits, testing their will, and fighting them hard. That's what study, that's what assertiveness is. That's where you have studied your facts, where you have the developing situation from the European Court of Justice. You have a belligerent, criminal, semi-criminal Irish government, and probably criminal, who will not obey the law. So we take the fight to them. We face them down, and we see how we do. We don't get too upset about it. We sleep sound, and we have fun. We have fun playing with them, because eventually we could actually win. And that means we block all wind farms. There was 4 wind farms due to go in for planning in October, and not one went in. And the companies, the wind companies and the energy companies are in the paper every day whinging about the delay and demanding something be done. And there is nothing the government can do. The government will break EU law, they'll get hammered again. But you see, the difference in going in on the whole planner programme from the start is everyone tries to stop you. But when a wind farm is granted, you are entitled to your judicial review on that specific wind farm. So they can't stop you getting into the courts. You're entitled to go in, you stamp your documents, and it has to go through the system. Whereas if you go in on the overall planner project, you have no specific thing to go in on. When you go in on the grant of the wind farm itself, you have a document there issued by Bortanola. You have the document, and this is what you're appealing. You're asking the judge to quash it. So you have something specific, and you have the right to go all the way up to the courts and all the way up to the European Court of Justice. And I have made it a policy that any group that has the money or not, I'll help them with it. Now, I have to say, I can't be held responsible for the information I give, because I won't be implementing it, and if people lose out because of the information I'm giving them, I cannot be held liable for that, and I will not be held liable. I'm not getting paid for this, or I'm not getting anything for it. I'm doing it for the protection of the environment. But where groups are ready, and where they're going to get lawyers, and they're going to use this, and they use it right, and that's why I can't take responsibility, because some people just don't get it. Some people think, but they don't have an environment report. But the point is, in a court of law, that's no good. You have to show that they don't have it, because the first thing they're going to say on a judicial review, you say we have no environmental report. Where's your evidence? So that's where the access to information on the environment request comes in. Your evidence is your piece of paper where they refuse to answer or they said they don't have it, and then your affidavit to say what you did, and you swear that and you're prepared to give evidence on it. And we have them cornered. I know from the grapevine they're very worried, particularly this farmer. Farmer with cows, like, you know, no, caught that fella. Yeah. And the fun I'm having with this and the crack I'm having with it, it makes you feel so good to be able to do the tough, take them on and handle them right and dig into them. It's really good crack. It's the best of fun. And I don't care who likes it or who doesn't like it. Because I could eventually pull down every wind farm in the country. If God spares me health. And as an old friend said one time, and the devil's not too bad either. So that's the story, folks. I think I've explained that to you, what we're at, and the devilment I'm up to for to save my environment, and the attitude I have to life, which is different to most other people. Strange, but anyway, I'm just bringing it to your attention. Give me a thumbs up for effort, or a thumbs down. We save our old green sod in the long run. We fight for it. It's worth fighting for. We'll see you back for something else, folks, and thank you for a big long video, and thank you for watching in and give me a thumbs up or a thumbs down if you don't approve. Bye.